We really appreciate you joining us on this Thursday afternoon in the dog days of summer. We've seen a lot of interest from people who are registered today, some of whom aren't able to attend live. And yes, we are recording this, and we will make sure that that link goes out to you when it is available. Before I introduce our panelists, I'd like to introduce myself. My name is Rebecca Vachon, and I am the Health Program Director at Cardus and will serve as the moderator today. Cardus is a nonpartisan think tank dedicated to clarifying and strengthening through research and dialogue the ways in which society's institutions can work together for the common good. Within Cardus Health, the issue of euthanasia and assisted suicide, or medical assistance in dying, or MAiD as it's referred to here in Canada, is a key preoccupation. MAiD is fast approaching 10 years of being legal in Canada, and as such, we are learning more and more about its impact on Canadians. So today we're previewing and discussing some findings from a forthcoming Cardus report authored by Alexander Raikin, which addresses the impacts of MAiD specifically on Canadians living with disabilities. We will have an opportunity for Q&A towards the end of our webinar today. So if you do have questions, please feel free to put them in the Q&A box, and we will try to get to as many as possible. I'll note that we do have a considerable challenge today, namely that we have only a limited amount of time and we have a lot of content. And so will be sending out in our follow-up emails some of the other writing of our panelists so that you can engage more with the content if there's something that's of interest. And on September 16th, we are publishing Alexander's report, and you will be able to get that link through your email as well. So without further ado, let me introduce our panelists. Alexander Raikin has a degree in public policy from Carleton University here in Ottawa, but is now living and working in Washington, D.C. as a visiting fellow at the Ethics and Public Policy Center. If you're following this issue, you've likely encountered his research and investigative journalism, whether in a previous report for Cardus, at the New Atlantis, or even discussed by other media such as the New York Times or the Atlantic. He has documented the rise of euthanasia in Canada, researched and drawn light into the issue of non-compliance among some MAiD providers, and brought human stories of MAID's impact to public awareness. You may have also seen some of his podcast interviews or radio appearances. So welcome, Alex, today. We are also pleased to introduce David Shannon, who brings his legal expertise and scholarship to our discussion. He is a lawyer practicing health law in Thunder Bay, Ontario, has a Master's of Law degree from the London School of Economics, lectures at post-secondary institutions, and has widely published on a number of human rights issues, including MAiD. He is also the co-editor of a 2023 Springer volume on the topic of MAiD. He's been awarded the Order of Ontario and the Order of Canada for his work in advancing the rights of persons living with disabilities. So thank you so much for joining us, Alex and David. All right, I'm going to start with you, Alex. This time last year, we published a paper that you wrote for Cardus that documented the rise of the assisted dying program in Canada as the world's fastest growing program. That attracted a lot of attention because just the scale of what was happening was really, really noticeable and really different than what we expected when the Supreme Court decisions and initial legislation came through. So now the second report, a year later, is focusing in specifically on the impact of MAiD on persons with disabilities. So could you tell us about how you came to research this question and what your overall finding is for the paper?
Yeah, thank you so much, Rebecca. It's truly an honor to be here speaking as part of Cardus. Look, I think it's important to start with this conversation with understanding just how quickly Canada's MAiD program has increased, right? Every day in 2023, on average, more than 40 Canadians died by the hands of their physicians or nurses. In 2016, in the first year of Canada's MAiD program, it was less than 3 Canadians per day. So this has been a tremendous increase. And what's sparked this interest is not just about the slippery slope in terms of overall numbers. It's about who is actually qualifying and dying for MAiD. And what we've seen is that if you look at any of the Supreme Court, the Supreme Court deliberations in Carter, if you look in the Truchon decision, which paved the way for MAiD to be expanded for people without a terminal illness, we see the same claim, which is, and I'm just going to read this out from the Truchon decision, is that neither the national data in Canada or Quebec nor the foreign data of assisted dying indicate any abuse, slippery slope, or even heightened risk for vulnerable people when imminent end of life is not an eligibility criterion for medical assistance in dying. And the problem with this is that on those three separate factors, right? Abuse, slippery slope, or heightened risk, is that we see that in Canada, there has been a tremendous increase in heightened risk for vulnerable people, and specifically people with disabilities. And that we've seen a massive slippery slope in terms of who is actually qualifying for MAiD. And what sets Canada's MAiD program apart from any other jurisdiction is that if you look at the only jurisdiction which has a larger euthanasia program per capita than Canada right now, the Netherlands, is that the majority of people who die through euthanasia in the Netherlands have an expected mortality of less than a month. The reality in Canada now, at least in Quebec, which is the only jurisdiction that records this information, is now a majority of people who die from MAiD in Canada have a natural life expectancy of over a month. The fastest growing segment is for those who have a life expectancy of more than 6 months. And when you compare the expectations in the Carter decision, in the Supreme Court decision, which first legalized assisted dying in Canada, or rather, just say decriminalized it, it was that the evidence that was submitted was that it was something along the lines of, like in the Netherlands, that only 0.2% of patients who would die through assisted dying would have a life expectancy of more than 6 months, and therefore it shows that people with disabilities would not be disproportionately impacted, only those who are imminently dying. Well, the data in Quebec now is that it is in the most recent year, in 2023, in the 2023 fiscal year, is that more than 20% of all MAiD deaths in Quebec were for patients whose life expectancy, according to their MAiD providers, was more than 6 months. Right, so this is a 200-fold difference from 0.2% to 20%. And we see this throughout the entire gamut of MAiD reporting, is that people with disabilities are now disproportionately impacted, and a majority of all MAiD deaths in Canada, according to Health Canada's own reporting, are either for people who have disabilities or for people who the MAiD providers do not know if they have a disability status or not. So I'll end it there because I'm also very interested to go through the questions. And you are right, we have a ton of material that we could cover. Thank you.
Well, so let me just make sure that I think we're understanding that core point. So if I'm understanding you correctly, in the Carter decision, the courts said, well, based on this data from other countries, the Netherlands, Belgium, Oregon, I think Washington State to a certain extent, we know that there's not a disproportionate impact on persons with disabilities because the life expectancy of those receiving MAiD is so short. Like they're only basically foregoing a few days or weeks of life. And what you're saying is, well, that was what the court said, but here's what the Canadian reality is.
Exactly. So when we look at what the expectations were, and this wasn't just the expectation of the Supreme Court, right, for the Carter decision, it's not just the ongoing expectations through, like Justice Baudouin in the Truchon decision, which paved the path for expansion of MAiD. This was also reflected in the ongoing estimates over life expectancy and over the financial cost savings for MAiD, right? So I think many of us here have heard of those estimates. Well, as late as 2018, there were estimates done of what is exactly the natural life expectancy for patients who apply, qualify, and die for MAiD. And the expectations, as late as 2018, was that 100% of patients who die with MAiD would have otherwise died in under a month. And the data in the 90s in Oregon and in the Netherlands was that the vast majority of patients, virtually all patients who qualify and die for euthanasia, would otherwise die in a matter of hours or days. And the reality in Canada is that has never happened, right? The slippery slope is not just about the overall numbers. It's not just about that the percentage of patients who tell their MAiD providers that they feel like a burden, and that's one of the reasons why they're applying for MAiD, has shot up now drastically, where now it's almost half of all MAiD deaths. It's not just that. It's about that even within the sort of legal conditions, right, that otherwise have remained the same, the patients who are now choosing to die for MAiD are further removed from a terminal illness. And this is important for us to understand because this should not be happening. The expectations that were laid out in their Cardus decision is not ancient history. It was just 10 years ago. And if you compare the evidence that was laid out over the Supreme Court's deliberation that people with disabilities and the elderly would not be disproportionately burdened through the legalization of a euthanasia program, and you compare those expectations with the reality in Canada today, is that we're seeing a massive and drastic increase in the percentage of vulnerable patients qualifying and dying for MAiD. And yet, none of this is being reported by Health Canada. The data is being reported, but the actual conclusions, right? What does it mean for there to be a slippery slope? Well, we have those expectations, and it's clear that we're not meeting those expectations in Canada today.
From the perspective of doing polling and talking to everyday Canadians about what they think about this subject, because it's one thing for the courts and Parliament to say that, but what's interesting is in the polling that Cardus has done, when you start to dig into what practices, Canadians will say, yes, I support MAiD overall in a majority. But then when you dig down into certain circumstances, and this was really well illustrated by a scholarly article, an academic article by Choi et al. From last year, where they showed that what Canadians actually support is MAiD as a last resort after treatments have been exhausted. And that's, I think, what your data, what you're showing us as well is that's not the case. That is definitely not what the actual evidence shows MAiD to be. So again, you have a disconnect between the expectations with Carter, the expectations when the program was brought in, but also the expectations that Canadians have when they think about the MAiD issue.
And I think you're exactly right, is that most Canadians just do not understand what exactly is happening with MAiD. And I think it's very important for us to emphasize that MAiD should not be a rubber-stamped process. The underlying logic of the Carter decision was that patients would apply for MAiD, but the vast majority of patients would not receive MAiD, right? It was more to be seen as a call for help, a call for additional resources, right? That people who have terminal illnesses, who have depression, who lack resources, would be able to apply for MAiD and receive life-saving medical treatment at the same time as there would be an option for MAiD as a last resort. And yet, I think that the clearest example that we have of rubber stamped MAiD process is when you look at the percentage of explicit requests for MAiD that end in MAiD deaths. And what we saw is that the evidence that was submitted to Carter was that for every 100 MAiD deaths in Oregon, there would be 900 other people who applied for assisted suicide but did not end up choosing and dying through assisted suicide. In the Netherlands, the evidence so this was in 1995, 1999, excuse me. In the Netherlands, the evidence that was submitted was of the data in 1995 in the Netherlands, which is that for every 100 euthanasia deaths, there would be 200 other people who applied for euthanasia but did not die through euthanasia. And this was core to the logic, which is that physicians would be scrupulous, that they would have a high system, would have a high rigor in order for processing the applications for their patients to die through effectively what is suicide. Now, the data in Canada, is that for every 100 euthanasia deaths in 2023, there were only 28 all their patients who applied for MAiD who did not die from MAiD. And I should say that this is up to 28 people who applied for MAiD and did not die from MAiD. And the reason why is because we have no data on how many of those end up applying for MAiD again and then dying from MAiD, right? So we went from a system which, according to the Supreme Court of Canada, was meant to be as an option of last resort. This was an argument that the plaintiff's lawyer in a Cardus decision used. Those were the exact words. And we went into a system which is now that instead of having the vast majority of people not qualifying, or rather to say not dying through MAiD, we instead have a system which is very much rubber stamped, and which the median MAiD application is submitted, processed, found 2 MAiD assessments, and ends in a MAiD provision all in less than 2 weeks. This is an absolutely incredulous pace, and I think it undergirds the fact that if you apply for MAiD, you're almost certainly going to qualify for it. There is no real scrutiny or rigor, and that which we not only should expect as Canadians, but also should expect on the basis of the Supreme Court decision in Carter.
Absolutely. David, I'd like to draw in your legal experience now to help us better understand the conclusions that the court came to, where they decided that we can essentially mitigate the risk that this might pose to persons living with disabilities who may be vulnerable, which is quite a contrast from the earlier decision, the Rodriguez decision in the 1990s as well, where the logic as a non-lawyer, so let's caveat that, the logic seemed to be you can't do this without putting people at risk of maybe being induced to take their life through an assisted death. So tell us more about how the Carter decision came to these conclusions. What's your take on it as a lawyer, but also as a lawyer who specifically does human rights law, who does disability law?
Thank you very much for the question. And we'll see with both Rodriguez and Carter, very interesting and somewhat similar facts where both persons had highly advanced and progressive forms of ALS. And they were both contemplating the end, or shall I say, the end of life. And but it's something of a cautionary tale, because although I'm not a constitutional law professor, and we don't have time to do a very deep dive, but we see with Rodriguez that the courts did have deference to Parliament. They also had deference to, they did not wish to be interventionist. They were very cautious. We see an absence of longitudinal studies in the Carter decision. We see that in the Carter decision, they were fine with judicial intervention. And also then where in Rodriguez, there was concern about community-based values and what we might see in a free and democratic society. In other words, what is the social makeup of Canada? And the social makeup of Canada says or suggests we cannot shock the conscience of our country, and therefore an infringement on such rights, such as a right to autonomy or liberty, or if there was a right to equality, there could be proportionally minimal interference. In the Carter decision, that interference was considered too extreme. It's very interesting, however, further in the Carter analysis, though, it focused almost exclusively on the rights of liberty, or those such freedom as liberty and security of the person, and did not look at an equality analysis. In other words, when I talk about equality, in other words, how is this going to impact the broad community of persons with disabilities in Canada? That wasn't part of the analysis in Carter. So in terms of the autonomy question, we see that in addition to autonomy, it was also very subjective. So if the person felt that their suffering was intolerable according to their own definition of it, not an objective standard, but a subjective standard of that intolerable suffering, so that they felt they couldn't go on, even if there was other elements at play. Therefore, we would have what might be called radical autonomy. And that key difference may point to some of the things that we've seen in the last 9 and 10 years with respect to MAiD. There is the so-called matter of choice, and that has been what much of the public has applauded, is that now people have a right to autonomous choice, and that rings well. However, the reality is it's a paradox of choice, and that is because much of the suffering, and I say, by the way, I've great lived experience. I know I'm on Zoom right now, but I do have quadriplegia due to a spinal cord injury. Over 90% of my practice, which is still quite robust, is in the area of legal aid. So I see daily the intersection of poverty and the social determinants of health, and how they intersect. You include further intersectionalities such as race, income, and then you start to see, as I do on a daily basis, that in fact autonomy and choice is a paradox, because if persons are suffering deeply through not being able to find a home, not having a job, that they are further impacted by, when I say maybe they have an apartment but they can't get heat in winter, when you start seeing this impact, it is truly a paradox, because one is forced into a choice out of distress rather than a clear, conscience-free choice of autonomy. So those are some of the major differences for Carter, and looking forward, maybe some of the gaps in the analysis in terms of a longitudinal view of what this would mean. For now, up to 30% of Canadians have a disability.
Thanks, David. And Alex, feel free to jump into the discussion as well. And I think it's really great to have the perspective of, we're having this view of the data and some of the evidence, but then also your experience of, as you're saying, working with people every day and seeing how this plays out in people's lives and seeing that choice. And Alex, I don't know if this is a good time to draw in some of those, maybe the data points that condition that choice, because one thing that you touch on in the report is, and I think you mentioned it earlier, is that many MAiD assessors are not even able to speak to whether or not the patient actually needed disability support, which I think raises questions about the assessment process itself and the degree of scrutiny there.
Yeah, that's I mean, this is probably the more disturbing part about this entire conversation. So I'm just sharing this is something that I've been trying to investigate for quite a while now. In fact, in one of the first papers that I wrote about MAiD in New Atlantis, there was all of this MAiD provider testimony that was presented. And this was a quote from a MAiD provider talking to a patient. And I'll just read this out. If we could change your housing, your financial situation, your social supports, would you want to die or would you want to live? And she was really clear. If I could go back to my home, I would want to live. I wouldn't want to die. This quote, which was part of a paper that was published, this quote never made the final cut. So this was discussed internally amongst MAiD providers, but it was never actually presented. And it's worth pointing this out, and this is sort of what I alluded to earlier, that it's not just, the question isn't just about abuse, right? Abuse is terrible. It is illegal. It would remain to be illegal regardless of whatever MAiD system it is. I'm interested, and this is what this paper is about, on the last two factors, right? Is there a slippery slope? And are there heightened risks? Because what is clear for the legal, for what is clear as part of the Card decision and as part of the Trishon decision was that there should not be a disproportionate impact on vulnerable groups, specifically people with disabilities and the elderly. And you asked an important question, but I'll just touch base first, right? That the expectation in the beginning was that there would be no euthanasia of disabled persons. We know now with the expansion of MAiD for people whose only condition is a disability, which, to be clear, it was already happening even before Bill C-7 expanded MAiD for Track 2, but since then it's further codified, that this has remained the case. And what is clear for the Carter, as part of the Carter decision, and again, it's a long quote, so forgive me, but it's important that to be accurate and reliable, the Supreme Court of Canada said that clinicians perform MAiD assessments would have to be aware of the risks of coercion, undue influence regarding the lives of persons with disabilities. Okay, well, the issue is you have a surprisingly large number of people who die through MAiD when the MAiD providers are unaware if their patient even has a disability or not, right? So you can see here in the federal reporting, so this is part of Health Canada's report, and this is the 2023 Ontario Chief Coroner's report on MAiD. And what we see for all of this is that a majority are people with disabilities or people who the MAiD provider are unaware if they have a disability status. And you can see that this is a surprisingly large number, right? And I think that there's a fundamental question here, which is how can a physician end up prescribing lethal medications and administrating lethal medications to a patient when they are unaware if their patient even has a disability? And I don't have an answer to that. But it is clear that it's happening, right? It is clear that this is quite systematic because this data is by MAiD providers to Health Canada, right? This isn't a survey. This is what MAiD providers are reporting of their own MAiD practice to Health Canada. And it seems to be that you have now thousands of cases. We have over 1,000 people who require disabilities but did not receive disabilities before dying from MAiD. We now have, again, almost half of all MAiD deaths are for people who require disability services. And you have a chunk now who, something like 20%, who the MAiD providers did not even know if they had a disability or not. And of those who MAiD providers believed had a disability, you also have another something like 10% where MAiD providers are unaware how long the disability, how long the person had disabilities, what support services they receive, how long those support services were received, right? So we're really talking about a pretty large problem, and I don't understand. I'll be frank. I don't understand how you can have how this meets the criteria within the Carter decision.
And I think you're getting at that point as well, is that, the data that we have on those disability supports, and this is also would extend to the palliative care data that we have at the MAiD federal reporting that is published through Health Canada, tells us nothing about the adequacy of those supports. It'll tell us a little bit about the length, but we don't know if this is actually meeting the needs of the people and if they are then requesting MAiD because of unmet care needs, as opposed to a real autonomous choice.
Right. It's more malicious than that even, because the MAiD, well, first of all, the MAiD reporting could very well have just asked that question to MAiD providers. Do you think that is the person who you are prescribing MAiD has a disability, right? And do you think that their disability supports are being met, right? A simple question. It could have been asked that. Instead, the way that disability supports are being recorded in Health Canada over-exaggerates the length of services. Now, what do I mean by this? I mean is that what they count as part of the reporting requirements is that you overcount the number of months that a person receives disability services. Because what they do is they add cumulatively every single individual disability service, right? So let's say you received one type of disability service, disability support for 6 months, and then you received another disability support in the last month of your life. The MAiD data would group all those and count that as 7 months of disability support. Right. So what it means, though, is that if you're someone who has complex needs, right, who requires additional disability supports, as part of the MAiD reporting schema, you are automatically counted as receiving more supports. Right. So it's and in a way that it breaks numbers and breaks our understanding of time. Right. So if you're someone who has never received an iota of disability supports, even though you required it 7 months ago, and then you applied for MAiD, right, the MAiD reporting process would record it as you having received that aid for a longer period of time. Right. So people who require more disability supports and who might only have received it in the last months of their life, who might have only received it a short time before applying for MAiD, those are the people who would be automatically recorded as meeting the standards. And this is deeply, deeply troubling.
Right. So you could be dealing with unmet needs for years and years. You can't get a wheelchair ramp up to get into your house in an accessible way. You're not getting some therapies that would be really beneficial. You apply for MAiD because you can't just go on based on all of these circumstances, and then you get maybe a month of mobility supports that last month. Well, that doesn't really address the problem beforehand, and whatever you're receiving at that time is almost too little too late as well. So how do you have an effective safeguard if it isn't really addressing the larger systemic issues?
Right.
So David, I'd like to pull you into this because you've written and from a legal perspective about the regulatory system. I'm thinking especially of the chapter in the volume that you co-edited, where you referred to the regime that was articulated in Carter and looked at, okay, what are the actual legislation and regulatory things that have been set up? And you referred to them, and I quote, at best superficial. So what's your take on the regulatory system? And are there some key changes that if you could speak to policymakers, what would you want to see changed so that we can maybe mitigate some of the impacts that people with disabilities and living with other kinds of vulnerabilities are experiencing?
And we look at some of the key points. I'm just so happy Alex is publishing in this and has a forthcoming publication, because to shed light on in a very comprehensive fashion some of the gaps and the need to close those gaps with the legislative and regulatory change. Indeed, pointing out the fact that there's been a negligible increase in funding for palliative care and home care right across Canada, but there's been a massive increase in funding for MAiD. It's so disproportionate. Life-affirming care is negated when MAiD is applauded by, or state sanctioned. Additionally, those who are filling in those very reports that Alex made reference to are the same persons who did it. Well, certainly they're not going to admit to an error. So there's not arm's length objective oversight of the process of one recording or reporting. And furthermore, if a person is declined when assessed, they can then doctor shop, and that should be stopped. The doctor shopping should be stopped if they've been assessed and declined. And finally, they can be assessed by video or telephone, as opposed to in office comprehensive assessment. All of that should be obviously reviewed, and I'd say stopped. But to go back to a recent report, just this March of this year, of the United Nations, they've recommended the track 2, in other words, the track that is exclusively for people who have disabilities, but for whom death is not naturally foreseeable, that law be repealed. And I've had to think about that a lot because it was quite a leap of the UN, but obviously it was the UN's experts committee on the United Nations Convention of the Rights of Persons with Disabilities. Deeply thoughtful. This was not just a a fringe group. Deeply thoughtful about all of the evidence before them. They have recommended Track 2 MAiD be stopped. I've thought about this a lot. I would have to agree. A repealing of or stopping Track 2 MAiD until there is a more thorough and comprehensive consideration of what this means, in particular, deep consideration of what all the points Alex has just made. More concretely, though, I would say revisit the definition of irremediability and suffering. So it's not just a subjective statement of an individual saying, I am suffering. There must be an objective component so that the medical practitioner must accept that, yes, there is ongoing suffering and there is no medication to assist that suffering. After all, suffering through both medication, social supports, good and comprehensive palliative care can be so reduced. Secondly, I would recommend that much more funding go into independent living, home care, and palliative care for MAiD. Incorporate vulnerability and social disenfranchisement as a risk to the error of the abuse of MAiD. In other words, there should be a much more consideration of the social determinants of health and the psychosocial elements that, if improved, would probably help people live affirmatively rather than fear suffering. Number 4, that there should be a multidisciplinary approach. Right now, the approach is so clinical dominant that the persons making the decision only know the biomedical aspects of the individual. I know there needs to be, or there's supposed to be referrals to or consultations with persons who have expertise in an individual's illness or disability. But again, it's about the experts, the professional. Very important to have people with lived experience who've made it to the other side of psychosocial adjustment, have been able to get past depression and adjusting to catastrophic injury or illness, social work, counseling, all critically important, and goes far beyond just the clinical aspects, which currently dominate the discourse. Number 5, access to MAiD must meet the ethical impairment that individuals suffering a mental disorder such as depression should not be able to utilize MAiD as a facilitation of suicide. As we know, in March of 2027, MAiD might be provided to persons with psychiatric disability as a sole criterion. Well, that I would argue that many forms of mental illness are remediable. I believe, I'm not a psychiatrist. Many psychiatrists could provide a much more comprehensive answer, but MAiD in the area of mental illness should not be allowed. And secondly, MAiD, if a person complains of a physical disability or illness, but really are suffering depression, this should not be a way of having MAiD for mental illness come in through the back door. Each province should have. Yes.
Oh, sorry. I'm just conscious that we're going to be moving to the Q&A in just a moment. But I thought that it'd be really important to pick up that aspect related to mental illness and depression, because Alex, you include data that shows that what was expected in Carter, namely that we're screening this out, that we're screening out people who might be making that decision on the basis of depression and mental illness, where a desire to no longer live is present would be screened out is not actually coming to fruition. So maybe could you just touch on that in 30 seconds before we move into the Q&A?
Yes, but I did just want to also just quickly mention, right, that the problems with MAiD is not just with track 2, right? I think that what this paper shows is that it really is the entirety of the MAiD system, which has just led to a disproportionate share amongst those who feel like a burden, who are socially isolated, who are vulnerable, whether because of disability status, whether because of advanced age, to qualify and die through this assisted suicide program just for those people. And, when you look at the Carter decision, the evidence that was submitted was that virtually no one who felt like they were a burden in Oregon in 1999, which you might think was pretty dated considering this was deliberated in 2015, but nevertheless, that was the most recent data that they used, was that Oregon data in 1999 was that almost no one who felt like they were a burden ended up actually dying through assisted suicide in Oregon. That is no longer true in Oregon, and it is especially not true in Canada, where now you have half of all people who die through MAiD now feeling like a burden, right? So the relationship flipped, right? Before these people were filtered out, and now these people are actively being facilitated. And this is also now around 20%, 22% of people who feel that they're socially isolated, who tell their MAiD providers that they feel socially isolated, are also qualifying and dying from MAiD. There was a massive increase in 2023 in the 2023 data over the 2022 data. Yet, for whatever reason, Health Canada did not pick this up. Not sure why, but to answer your question, the other part is also with depression. We've seen from multiple independent chart reviews of medical facilities all across Canada, in Ontario, in Quebec, in Nova Scotia, that people who apply for MAiD disproportionately have psychiatric illnesses. We know that virtually all of them, 96%, have psychosocial issues and psychological issues when as part of their illness. And yet almost no one receives psychiatric care as part of the MAiD application. In the first year of Oregon's assisted suicide program, around a quarter of patients who apply for MAiD ended up having psychiatric consultation. Now, even in Oregon, it's virtually non-existent. Well, in the first years of Canada's MAiD program in Ontario, we know that only 6% received any form of psychological or psychiatric care as part of their MAiD application. Now that figure is even lower. So we have a system where people with psychological issues who have a disproportionate share of depression and other psychiatric illnesses are applying for MAiD. And yet those same conditions are not being adequately met before their application. And considering that the MAiD process itself is now so expedited, where you have same day provision and assessment and provision for MAiD, I think that this is quite jarring. Right? Is that first of all, this issue isn't even being widely discussed amongst Canada's medical associations, and yet we have now quite a plethora of independent papers all showing that that for patients who request MAiD, that they're disproportionately likely to have psychiatric illnesses, and that their psychiatric needs are not being met before or during their MAiD application.
Well, that's very concerning. And David, I realize I cut you off a little bit on your final recommendations, but I have a question that touches on the question of reporting. So I think that'll let you to get back into the point you were going to make. So one of the questions from our viewers is about the MAiD data and why do we have more robust MAiD data in Quebec compared to the rest of Canada? And maybe, David, if you'd like to add on some of what you were going to say about the need for a better monitoring system while we're at it.
Yes, and that monitoring system, well, as many would know, in terms of one of the difficulties with MAiD from the get-go was that it was an amendment to the criminal code. So when one takes a penal code and tries to engineer a brand new program that it affects both society and the healthcare system, there's incongruity right off the bat. And so, of course, this would then delegate to the provinces because the provinces have jurisdiction over healthcare and social services. Then in terms of the choice of each province and how they will monitor and provide oversight of MAiD within the healthcare system will change and potentially change radically from province to province. And so we have one system for Quebec, a different one for Ontario, and each province. I would recommend that oversight body should in fact be arm's length, independent, and it not be just an advisory body, but in fact have powers of enforcement where there are very real concerns about errors and other such failure to meet criteria, such as depression or suicidality, rather than the inherent end of life. That was the original purpose of Carter. Right now, that does not exist in Canada. And therefore, there's not robust monitoring. There's not robust record keeping.
Yeah, and I would just touch, if it's all right.
I was about to say, Alex, can you tell us more about Quebec specifically? Because I also know that you've spent a lot of time digging through the Quebec reports that are produced.
Yes. Now, I just on David's point about errors, it's worth emphasizing this, which is that we've reached a point where Quebec's independent monitoring agency for MAiD now regularly reports that in every single year, when they break down based on the underlying illness of people who apply and died for MAiD in the province in Quebec, that their underlying illness, underneath cancer, underneath neurological conditions, is no illness that qualifies under Quebec's law on MAiD. That is, quite frankly, insane. And yet, absolutely no repercussions have happened to any of the physicians who have prescribed and administered euthanasia to patients who, according to the monitoring agency, did not qualify under Quebec's own law on MAiD. We see that these errors are all across Canada. We see that, so I wrote a report in the New Atlantis that something like 1 in 3 MAiD providers were found by the Chief Coroner's Office of having violated some of the rules, at least one of the rules with MAiD in 2024. We see that there was a report that came out in BC Catholic, I believe last week, or a couple of weeks ago. Forgive me for not understanding how time works. But in BC, that there were similar high rates of MAiD providers not completing legally required compliance forms, or including missing documentation, missing forms, not completing it in time. And even that there's been over a dozen cases where the BC College of Physicians and Surgeons were notified about misconduct. So this abuse and errors, or apparent abuse and errors, according to the monitoring agencies, is happening all across Canada. There has been virtually no repercussions for any of these MAiD providers who have violated what is fundamentally a criminal law on euthanasia. So this isn't just, it seems to be a scandal and it seems to be a wrong thing on a moral level, but this is also a problem on a legal level, because the Supreme Court of Canada quite explicitly said that vulnerable patients would be protected from abuse and errors. So if I do not have any information that this is necessarily abuse as opposed to just errors, but it doesn't change the overall structure of this, right? Which is that vulnerable patients should be protected from abuse and errors. We know that errors with the MAiD process are extremely high, and we know that these errors are happening in 3 provinces on a systematic level, and yet there's also been very little pushback on this.
And the gravity of the consequence. I'm sorry, and to highlight that, the gravity of the consequences are so severe because already the person is dead. So a retrospective report that puts out some executive summaries and details perhaps errors and mistakes if it doesn't work proactively, then in fact it's not working.
Yeah, and I mean, one thing that I did appreciate from the province of Ontario was the work done by the MAiD Review Committee that was set up by the Chief Coroner's Office. And some of the discussion in their reporting and going through some of the case files and bringing some of those details, obviously in a confidential way, but bringing some of that human side to bear and showing how much cause for concern there should be because of the influence of untreated or undertreated addictions or mental illness or the role of caregiver burnout. There's that kind of type of data as well that I think is an important part of the picture that we don't get from really any other province. And we
Right.
were, I think, lucky to get, in a sense, from the Ontario Coroner's Office.
So there is an issue with the coroner's office as well, is because there's really two different review panels, right? So there's an advisory review panel, which is the report, which is what the reports that we've seen that have come out is from this advisory board. But then there's another review board, which is primarily nurses who are and I think this is where the drawback is that the advisory reports have been very well done and have flagged many of those issues, and yet the issue is that we're having. Am I back? Do we have? Okay.
Yeah, you're back. Yeah.
Apologies. Sorry, I was just saying was that there's great work that's being done by the advisory board, and yet the issue is that you have this separate nursing board, which is and this board is the one who has flagged misconduct of some sort or errors of some sort, and yet the chief coroner's. The chief coroner of Ontario sent out a memo to every single healthcare physician that there were violations of provincial regulations and of the criminal code. He discussed he discussed in some cases there was a blatant violation. He discussed cases where there was a lack of non-compliance, where there's a pattern of non-compliance. That was the wording that he used. And these issues have been happening since virtually the first 100 MAiD deaths in Ontario. And yet we are now 10 years removed from that, right? It's been 10 years since the Cardus decision. It's been 9 years that MAiD has been legalized in the province of Ontario. And this same pattern of non-compliance seems to be ongoing. And yet the chief coroner's response was only a public statement. I think the last public statement was something around 2019, right? So it's been many years since there was a public statement by the chief coroner himself on this issue, even though as these violations have increased and even as the numbers of errors continues to increase as the number of MAiD cases also increase in Ontario, right? So I think that it's a very substantial issue. And I don't know if we can have that. I don't know how this isn't a larger issue in Ontario, that the chief coroner himself has been reporting to MAiD providers many, many times that there have been ongoing violations of the criminal laws with MAiD.
On that note, there's a question that asks, has there been a reference to the Supreme Court eligibility criteria for MAiD being violated? If I'm understanding correctly, is it, I think that they're asking about, are there court cases that are essentially challenging certain MAiD decisions? So, David, I don't know if you'd like to speak to that. And then there's also a question related to the judicial decisions asking about, do you think the change of language from assisted suicide to assistance in dying played a role in the judicial decision?
In terms of, I am aware anecdotally that there is one matter working its way through the courts that's with reference to MAiD. I'm not part of that or privy to those discussions. So I say that from an outsider's perspective, that there is one case working its way through the appellate court system. Secondly, sorry, what was the second part to the question?
It was asking about the language, if
Yes.
the assisted suicide language, and I think heavily used in Rodriguez, we see a shift
Yeah.
in the judicial decision.
Clearly, there was an influence from an intervener or a lobby group that did wish to impact and change the language from euthanasia to the more euphemistically stated assistance in dying or medical assistance in dying, making it sound much more benign. And that has been a story for the past decade or decade and a half, and we see that continue to play out, and then being grabbed on by the mainstream, certainly by media, and it becoming mainstream discourse. That is, and I do believe that has certainly impacted I would argue a false sense of benevolence, or that MAiD being benign, as opposed to it requiring a much more serious consideration. I should say, I should say it also is negatively impacting, I would say, negatively impacting the patient-physician relationship, because it's so evident. It's very difficult to find a hospital where there's a MAiD-free space, and so they're going to start hearing the euphemistic terms and feeling potentially being manipulated into it. There is an outside influence with this false sense of ease in such a critical and grave medical procedure.
Yeah, and I think as well, right? Like that, I think that the trouble is not so much calling it assistance in dying or assisted suicide. I think the issue is the assisted part, right? And specifically as a medical act, right? So when it takes this Canadian Institute of Health Information, when they report that it takes over a month, on average, the median Canadian takes over a month in order to receive a CT scan, which is not which is not an elective procedure. It's a priority procedure, right? No one chooses that they want to have a CT scan does, right? There's a priority procedure by a physician. And when it takes more than a month to receive a CT scan, and yet at the same time that an oral request for MAiD goes through all the MAiD assessment process, that you find two different physicians or nurse practitioners, that you finalize your end of life wishes, you schedule the appointment, and you have a physician or nurse practitioner coming to your home. And that entire process takes something like 11 days in 2023. I think that undergirds the entire problems with the system, right? We have now same-day provision and assessment for MAiD. We know that this is systematically happening. Then MAiD, as the M in MAiD, is being prioritized, while life-saving medical care does not receive that same level of attention and funding.
I'd like to, we're going to have to wrap up in just a moment. So I'd like to ask both of you if there's one thing that you think we should take away from this conversation. I'd say especially for, if someone's like, this doesn't really affect my choice, I'm not going to make this choice, my mom's not going to make this choice. Why should they care about the impact this may be having on other Canadians in like 20 seconds each?
Do you want me to go first? Okay, great. Look, I think ultimately the issue is that in the scheme of personal choice, we are still meant to follow the Supreme Court's expectations. And when the Supreme Court of Canada legalized assisted suicide and euthanasia, it was on the basis that vulnerable Canadians would not be disproportionately impacted. Right. The undergirding argument is that vulnerable patients should not be sacrificed on the altar of human choice or human autonomy.
Okay,
And what we're
cutting
seeing
you
in Canada
there.
is that this is happening. Okay.
Okay, and David.
Over 60,000 Canadians have already gone to MAiD. Everyone is going to be impacted by MAiD. Everyone knows someone with a disability. And if now there is going to be undue influence on persons with disability or those at the early stages of an illness that is quite treatable, it is impacting all of us. This is also a larger question of death, bereavement, and grief. And it has deep and profound social and familial impact. And we have to acknowledge that, acknowledge the bereavement, and take care as a much broader society that it's not just about a singular autonomy, but it's about all of us connected as a meaningful community of Canada.
That's a great note to end on. Thank you both. Thank you so much to our audience. I'm sorry we weren't able to get to every single question. As I mentioned at the beginning, we are going to send a follow-up email. We're going to link some of the other work of our panelists that may be of interest and may give you some more detail as to those questions or other questions you didn't even think of. We also will be releasing Alexander's report, going through this in detail on September 16th. We're looking forward to getting that content to you as well. You can also stay in touch with Cardus Health through our newsletters. We also have an upcoming webinar that you might be interested in on September 9th, entitled Can Christians Fully Participate in 21st Century Pluralism? And that features Father Deacon Andrew Bennett, who is from Cardus, and Professor James Orr from Cambridge University. So a huge thank you to all of you and our audience. A big thank you to Alexander and David. Thank you so much for sharing your research, your expertise on this topic that's so important, and for bearing with me with these difficult time constraints. We really appreciate that. And last but not least, thank you so much to my Cardus colleagues who are behind the scenes and make sure that this process goes well. So that is it from us today. Thank you so much all for joining us, and we hope to see you at a future Cardus webinar or event sometime in the future.